A Minnesota jury has found former police officer Kim Potter guilty of fatally shooting Daunte Wright during a traffic stop last year.
In the matter of State of Minnesota versus Kimberly Potter, court file number 27 CR 217490, we, the jury, on the charge of manslaughter in the first degree while committing a misdemeanor on or about April 11, 2021, in Hennepin County, State of Minnesota, find the defendant guilty.
Jurors also found the veteran officer guilty of second-degree manslaughter, culpable negligence on Thursday. Court officials took her away in handcuffs shortly after the judge revoked her bail. During the trial, Potter said she did not realize she grabbed her gun instead of her taser when she shot Wright. The jury consisted of one black person, 2 Asian American people, and 9 white people. Potter's sentencing is set for February 18th. And for more on this, we want to bring in CBS News legal contributor Jessica Levinson. Jessica, why did the jury have such a hard time with this case?
Well, I think because, the facts weren't in dispute. It wasn't necessarily clear to them whether or not this accident rose to the level of being criminally culpable. And I also think, honestly, because when we talk about manslaughter and we talk about words like culpable negligence, or reasonably foreseeable, that these are words that are open to interpretation. But obviously, if you find actions that fall within it, there's huge repercussions for, in this case, Kim Potter. And so I think that the jury was also struggling with these fairly broad terms that allow them really to exercise their discretion. Was it reasonably foreseeable that when Kim Potter reached for that weapon, that she was potentially putting Mr. Wright in this type of grave danger? What does it mean to be culpably negligent? A lot of it deals with things like the reasonable person standard, and that's not necessarily always straightforward. Clearly, the crimes here weren't ones where the prosecution had to show intent. In some ways, it can be more difficult to try and convince a jury that somebody should reasonably foresee something.
The jury deliberated for about 28 hours, and as the news broke, we saw a lot of people analyzing that it would be a hung jury, but they did find her guilty on 2 manslaughter charges. What do you think it was about the prosecution's case that persuaded jurors to convict Kim Potter?
It's interesting. I've thought about this because it is on the kind of outside of the time frame where you might expect. And I think what helped the prosecutors actually is when the jury came back and they said, can we hold the weapon? I believe that there was a question of basically, can we hold the gun when it's not loaded? That they were really trying to figure out, if I was in her position and I grabbed for a gun, not a taser, would I understand that quickly in that moment? Would it be reasonably foreseeable? Should a reasonable person understand that that's a gun and not a taser, particularly a reasonable person who's trained on that? So I think that was very helpful for the prosecution. Obviously, the prosecution didn't have to argue any facts that were in dispute here. I think a lot of this was arguments also on the idea of some police accountability, on the idea that based on her training. And frankly, I think that the prosecution also had a good moment on cross-examination when they said, well, was there any threat to you? Or was this just somebody who was trying to evade arrest? And did you try and help after the shooting? I think those were 2 really helpful moments for the prosecution.
There was a little back and forth about her sentencing, about Kim Potter's sentencing. The judge initially said 3 weeks from now. They threw out the date January 13th, January 14th. And the judge said that, she would be held without bail. Her defense argued that it was Christmas. She is a devout Catholic. She wants to go home. She will continue to be held without bail, and she will be sentenced in early March. What will Kim Potter's sentencing look like?
So what we heard in all of that, and this is kind of an amazing education for a lot of people who don't look and see what's happening in courtrooms every day. What we heard is a lot of discussion of scheduling. Why? Because both sides are going to put forward their sentencing memos, their arguments for why the sentence should be lower than the maximum, which I believe is 15 years here for that first-degree manslaughter, and or why it should be at or close to the maximum. There's some things that are not in dispute. Kim Potter has not been in trouble before, but you heard both sides say, well, there's some issues that didn't come out in trial, and I think that they would be helpful, Your Honor, for you to hear for sentencing. So what the judge said in this case is, I can't treat this defendant as any different from anybody else, so she will be behind bars before sentencing. And then as we talked about for sentencing, basically the prosecution is going to say, here's why there are some aggravating factors, or here's why the sentence should be higher. The defense will say, this is somebody who poses no risk to the community, and here are some mitigating factors. Here's why the sentence should be lower than for a first-time offender who is convicted of these charges.
You just mentioned that the judge said that she cannot treat this case like any other case, right? But it is in the background. What is in the background is the Derek Chauvin case, which happened not too long ago, right in this same area. And the jury found both officers, well, now former officers, guilty in those deaths. Does that surprise you? Does that show a changing of the tide in these cases?
So in a way, I'm of two minds. So there are two cases with facts regarding police officers who committed actions that led to deaths. Obviously, very different cases in terms of Officer Chauvin being convicted of murder, in terms of former Officer Potter here being convicted of manslaughter, but similarities: 2 white police officers, 2 black victims. And so in some ways we can say, is this a moment where juries' minds are changing, where they're becoming more attuned to the need for police accountability? On the other hand, I think we should be careful about drawing too many conclusions and creating kind of broader themes, because 2 of these trials happen somewhat close in time and have some similarities. Now, it may be the case that we see juries changing in terms of when they're exercising their discretion for what's foreseeable. In what situations can we say a police officer must be held accountable? But I do want to be careful, just based on 2 cases. I don't know that this represents a sea change when it comes to how juries will think about these cases against police officers.
When the verdict was read, Kim Potter was pretty stoic, quite different than what we saw her in her testimony. We did see, however, one of the defense attorneys kind of collapse on the desk a bit. He seemed to be a little more verbal, I guess, in his body language. And then there are arguments to why she should not be in custody. What did you think of that? He said that it's Christmas, she's a devout Catholic, her family would want to see her. Was that a strong argument, you think, knowing the case?
I think that it was about as strong as he possibly could have made it. So he obviously is saying here, I think what he's saying is 2 things. Basically, Your Honor, please take pity on her. It's Christmas. It's a holiday that's deeply important to her and her family. And also, taking aside the emotional aspect of this, saying she's not a risk. And maybe I heard the attorney saying, look, we don't know what your sentence is going to be. Your sentence could be no time. And therefore, if there is going to be time served, there's no reason that we can't put this off. That's about as strong as a defense attorney can get in terms of arguing there's really no public purpose to putting this person behind bars. Was it persuasive? Obviously, not to the judge, who said, basically, I understand what you're saying. Under the subtext, I understand the emotion here, but I can't treat this case as different, again, subtext, just because we're on TV. And so that, I think the defense really argued everything they could, but the judge really clearly saying, this wouldn't fly for another defendant, so it can't fly for this defendant.
Jessica Levinson, thank you.
Thank you.